and for a lot, most students don't see that that's not amazing. We're making her talk for like that's my favorite grade. Okay. All right. All right. Okay. Thank you. Thank you.
I remember.
I
haven't seen it. I would love to see it. I forget what I had going on when I was devastated. He was in charge of it. You leave that journal? I'm doing one. I was just saying.
Good evening. I'm Leah Slade. I'm the president of the League of Women Voters of Greater Birmingham, and I'd like to welcome you all on a beautifully rainy night to a panel that has been long in gestation. But we are happy to have these esteemed panelists here, and I'm going to allow our moderator to introduce each of them. I will introduce the moderator. First, a couple of admin announcements. For those of you who are in league or interested in what we are offering in the future, our meeting next month will be with the acting executive director of the Birmingham Transit Authority. We visited with them February a year ago. Much has happened. We're going to revisit what's going on with transit in Birmingham in March. In April, we're going to expand to an international look, and we have as our guest speaker retired Major General James W. Darden, who's the Army Reserve Ambassador for Alabama, and a former commander and a former high official in European Command. He's going to talk with us about NATO and global coalitions in the 21st century. So as you can see, we cover a lot of territory in League. Tonight, as we usually do, if you have questions, please raise your hand, and one of our members will bring an index card and a pen. And if you will write your question down, we will get those to our moderator. She can look at them for a couple of reasons. Sometimes we have questions that are almost the same, so she can consolidate and ask maybe a broader question. Also, sometimes we don't catch all the questions, so we beg the indulgence of the participants, and we ask them to give us answers, which we post on our website, so that if we run out of time, then you know that your question will be addressed and answered on our website. So let me now go to the main event of the evening. We are honored and thrilled to have as our moderator tonight Trish Powell Crane. And I knew her when she was being the genius behind the Alabama School Connection, which became famous statewide for factual, clear analysis of what was going on in education in Alabama. Because of that, she developed a number of insights and contacts. As a result, AL.com saw what they were missing, and they've asked Trish to be their full-time education analyst. Because she knows so many people and she knows how to ask questions, you may have noticed the number of page one stories that AL.com has been carrying about education in Alabama and how maybe national trends are affecting what's happening. So we're going to try to cover a lot of territory tonight. We are going to be finished by 8:30. We may have a break, but we want to make sure all of your questions get answered. So I am delighted to introduce LWGB member, and our moderator tonight, Trish Crane.
Thank you. Do I need to use that microphone? Can everybody hear me? Okay. So there are plenty of seats. Please feel free. This is going to be very conversational. I have no notes. I went like a millennial and put them here on my iPhone. My children will be proud. They are millennials. A couple of them, anyway. So I appreciate you being here tonight. This is a very important topic to me personally. I grew up in Hoover. I grew up, attended Jefferson County schools, and then, was a child of the early 70s, saw the school systems break apart. We lived in the over-the-mountain suburb. Hoover remained a part of Jefferson County for a long time, broke off after I graduated, became its own city school system, and I just have a thing for wanting to see kids get great opportunities. I raised my children as a single mom for 20 years, and I saw that, when you don't have when your family doesn't look the same way as everybody's around you, sometimes you can get, you kind of get pushed a little to the side, and so I think that was my very fortunate, that was my only instance of not feeling like the rest of the group, but it pointed the way to understanding that not everybody has access to the same education, the same opportunities. And so I have made some friends along the way, and I like to call these people my friends. They are experts in their field, absolutely thrilled that they're here tonight. It really means a lot to me. And I'm just using this forum just to get to see y'all and ask you the questions that I've been wanting to ask you. I am a reporter for AL.com. I'm the statewide education reporter, and I do get to write a lot, and it's a lot of fun. So we are streaming this live on Facebook, just to let everybody know. And my mother's in the front row, so it's not like I'm nervous or anything. So. And my uncle too. It's a family thing. So we have. Wait, is that family member? Is that?
Oh, old hometown friends.
Okay, old hometown friends. So we're
Well,
gonna get
I don't
started.
have any family members here.
Oh.
Actually, I may be related to some of you.
Well, and we're going to take some time. I'm going to tell you how this is going to go. I'm going to introduce everybody, and then I've asked each person, in turn, each of our panelists, to talk a little bit about their area of expertise. They sort of have different universes around the school desegregation and integration world that they can bring some knowledge to us, too. I've learned a lot from all three of these people. I've picked their brains at various times. I'm going to start on the far side. This is Dr. Joseph Bagley. Dr. Bagley has written a book, and I found it when it was a PDF, and I was so excited about 5 years ago. It was a dissertation. Yeah. The crux of it was, right? Yep. And it was a history of school desegregation in Alabama, the use of the courts from 1954 to 73. Mm-hmm. That history isn't anywhere else. Like, you can't find it anywhere else. So it was just right there in searchable format, and it was really helpful to me at a time when I was trying to sort out some things that were happening in Hoover. I'll leave it at that. But Dr. Bagley comes to us from Perimeter College at Georgia State. Mm-hmm. He is a professor of history. Perimeter College is the 2-year. I'm just learning about that Perimeter College joined with Georgia State, and they're kind of like consolidated now, and I thought, God, that's smart. But Dr. Bagley is going to talk to us about that historical perspective. I grew up here, and I never learned that history. And a lot of us who lived here didn't read it in the newspapers. And we were not made privy to this knowledge until we were good and grown. So I'm really looking forward to hearing from Dr. Bagley. And he's driven a long way tonight, and I really appreciate that. In the middle, we have Whit Colvin. Mr. Colvin, I bugged him a few years ago, and he has not been able to shake me since. He's very generous, very kind with his knowledge. A mutual friend said, Whit, would you just tell Trish about how school desegregation's been going in Alabama? And I was like, okay. And I remember, I was actually sitting in front of the federal courthouse about to go inside and do some research, and I had used too much time outside, I didn't have time to go inside. But Whit is an attorney for Bishop Colvin and Kent, which is a law firm here in town. They represent school boards. They do other types of law, but mostly it's
Mostly school boards.
mostly school boards. And that's really not a common thing. There are not a whole lot of school board attorneys. He has lots of clients. We're not getting personal tonight. We're not going to talk about his clients. He's not going to talk about his clients.
Not much, at least.
Yeah, not by name. He'll just describe them, and I'll flash up a card as to but Whit has a personal history with all of this, too. I think this is fascinating, and I'm going to mess it up, so you might have to correct me.
Yeah.
But many of you may know Judge Pointer played a big role. Sam Pointer, who my family has a connection to. I haven't told you that. But Judge Pointer had a law clerk, and it was Whit's father. So Whit's father was a clerk for Judge Pointer back in the day.
When he was writing the desegregation orders that we now operate under, which is pretty fascinating.
Yeah, I mean, and then I guess you just fell into it and just couldn't tear yourself away.
He raised me to be a desegregation lawyer, because there are a lot of us out there. Not really. I just happened into it, and I'll tell you the story when it's my turn.
I appreciate that. I look forward to that. And Whit has done work not only for local school boards, but also for the state of Alabama, for the Department of Education, helped them through some really complicated cases, because, we're here because federal desegregation orders are still alive and well in Alabama. And we will get to that. So he's going to give us sort of that overview of, like, what does that look like from a legal perspective now in Alabama. Dr. Orletta Rush joins us from, she works at the Jefferson County School District and is the Executive Director of Special Initiatives. And in this particular case, she is in charge of Jefferson County's effort to gain unitary status, which means, I know y'all, I'm going to try it, y'all can catch me if I'm wrong. When you're gaining unitary status, what you're saying is we've done everything we need to do, and we no longer maintain a dual school system. One school system for black children and one school system for white children, school children. So this is an ongoing process. The original order is from 1971, but the court case was 65, which was the year I was born, just to, for what that's worth. So it's really interesting. It's like, history is still alive and well, and that is not always good for our kids in schools. So we have, I'm going to stop talking now. Dr. Rush, thank you for being here. She is really the one on the ground working with teachers in classrooms about discipline disparities, about academic opportunities for kids. I mean, this is hard work. This is everyday work to maintain equitable opportunities for kids. So without further ado, I'm going to back up over here. What we're going to do, we're going to let each of our panelists talk about their area of expertise. And I'm going to sort of monitor time, but we've got a couple hours, so I'm not too worried about it. Be writing down questions if you have them. And then after all three get an opportunity to speak, I'll probably have 3 or 4 questions over here that I'd like to ask. And then, of course, we'll open it up to y'all's questions. And hopefully the weather won't get any worse than it is. If the power goes out, I have an iPhone, and I'll turn my flashlight on. So without that further ado, Dr. Bagley, I was hoping that you would give us that historical perspective of what happened. We had this thing called Brown v. Board and the Board of Education of Topeka.
Yep.
In 1954, federal court said you have to integrate.
And it's like I asked my students in my U.S. history survey, and they know enough by that point to know the answer. I said, do you reckon that state, local governments in Alabama or Mississippi or wherever at the time said, oh, well, I guess we got to go ahead and integrate our schools? Of course not. In fact, it would be 9 years before one single African-American child attended what would be then a formerly all-white school in Alabama. Before I'll pick it back up there, you and I were chatting, Tricia, just before, and about sort of my history with this, and I'm from here as well. I grew up in Helena, My mom was on the Shelby County School Board for a little while back then. But we ended up moving to Opelika, and I went to school there. Helena at the time. What's that?
That's where she's from.
This is fantastic.
Yes.
Well, we have much to talk about then. All right. Well, then you'll be intimately familiar with what I'm about to say. Helena, or Shelby County at least, was Helena at that time. We only had a few African American students. When I moved to Opelika, this was a substantially integrated school system. That obviously took some doing. I'll say something about that here in my remarks. But that was a new experience for me, one that I'm blessed to have had, honestly. But when I first got down there, obviously there was adjustment to that, but to the high school at the time, I remember thinking, this school system has a lot of money, and the high school is a tin can. I remember asking people, why is this high school what it is? And they're like, yeah, they had to throw that up in like 9 months because of integration. I was like, but it says 1972 on the front. That surely integration didn't occur here in 1970. Come to find out, it only started to occur in the 1970s. And so that's what sparked my interest in this topic. And like Trish was saying, this is not something that you learn about when you're at Opelika or at Helena or anywhere else coming up in grade school in Alabama. So that's what sparked my interest in it as a history major. That and the fact that my professor in senior thesis summarily rejected the notion that I could write my senior thesis about the Battle of Stalingrad. As if anybody in Auburn, Alabama had anything new to say about the Battle of Stalingrad. So I wrote my senior thesis and my master's thesis and then ultimately my dissertation on this topic.
You had Dr. Flint, I said.
Oh, yeah, Dr. Flint, Wayne Flint, legend of Auburn historians. I did not have him for senior thesis, regrettably. He was kind of on his way out the door to semi-retirement at that time. But he's written extensively, as some of you probably know, about Alabama's tortured history, such as it is.
He served as our expert in the statewide case.
That's
on
right.
Facilities as well, and it's
Okay.
done a video. It's about it. It's the video we used since we have the Auburn connection. To educate all of the school board facility managers throughout the state on desegregation and the importance of making decisions that were designed to provide equity.
Yep.
So,
He was expert witness, too, on a case that, if I have time, I'll mention. He was,
we
two
have
cases.
times.
Yeah, Knight versus Alabama and
Yeah.
Lynch versus Alabama. These were aimed at two amendments to our archaic 1901 Constitution called the Lid Bill amendments. So I'll hopefully dovetail back around to that. Back, though, to Brown, as I said, it was 9 years until there was any desegregation, and we usually use that to refer to just breaking the color barrier at all, as opposed to actual genuine integration, the likes of which I encountered in Opelika. So what happened during those 9 years? A period of what historians have traditionally called massive resistance. That is massive white resistance to any kind of desegregation at all. In my book, I'm trying to move us away from using that term to refer to just that period of time, because my contention is that massive resistance didn't die, it just adapted in a lot of important ways that made it enduring and unfortunately more effective in the long term. But what did massive resistance look like, especially after the court handed down the year after what we call Brown 1, Brown 2, the implementation decree, to have a uniform or unanimous court, they deliberately left the implementation decree vague and used phrases like all deliberate speed and a good faith start, phrases that still are floating around in the litigation. So all this means is it was left to the federal trial courts. It was left to individuals to bring suits against every single school board and every single county and city across the South and beyond to get them to recognize the validity of Brown. The NAACP in Alabama set about doing that immediately under what the NAACP called Operation Implementation, where they would petition school boards and say, hey, you've heard about this Brown decision, right? Well, what's your plan to meet that decision? In response to that, segregationists organized what they call citizens' councils, white citizens' councils. This was thought to be a more effective counterpart to the violent resistance of the Ku Klux Klan. Citizens councils would use economic reprisal against any of these people who would sign NAACP petitions. I must be in the heart of SEC country. These people in the citizens councils, they would publish the names of the signatories, and all of a sudden everybody who had signed these NAACP petitions, they'd be out of a job, they would be evicted, they would find it impossible to get credit or anything like that. So that is the way that the councils operated, and they began to proliferate. It started in Mississippi, but they very quickly spread into Alabama in 54, 55, and there were dozens of them by the 1960s. At the same time, the state legislature passed law after law after law, knowing that every single law they passed to try to thwart integration would have to wind up in court too, and that's another court case, and that's more time and money and delay. They also banished the NAACP from the state of Alabama. Governor John Patterson at one point was able to do that, and so that is a legal battle that had to be fought as well. At the same time, you begin to see the opening of private schools for whites who would flee public school systems that were threatened with any kind of desegregation, commonly known as segregation academies. Take any, especially in the Black Belt, any county name and fill that county name in with such and such academy, and look in the historical record for when that county was threatened with a desegregation suit, or as I'm about to talk about in just a minute, when they were threatened with moving to more substantial integration, and you can probably find that one of those academies was open at that same time. There was litigation during that 9-year period. Probably everybody in this room is familiar with Fred Shuttlesworth. He filed Alabama's first school desegregation case, which was aimed. I'm sorry.
Your voice is like trailing off at the end of each of your sentences.
I'm sorry.
You're not going to use the microphone.
I meant to also apologize. I'm a little under the weather. You can't tell. So.
Do we want to use the microphone?
Just say the right time.
I can project if this is better.
Use your professor
He's
voice.
a teacher. He's got this.
Yeah. Okay. All right.
Do you want to stand up? Would that
Yeah.
make you feel better?
That's more my MO anyway. Sorry. So I was just talking about the beginnings of litigation in this state. Fred Shuttlesworth, who's familiar probably to most of you, the icon of the civil rights movement here in Birmingham. He orchestrated the filing of the first desegregation suit in the state, which was aimed at what was known as the pupil placement law. This was a law that the state passed, which, on its face is what historians call colorblind, which just means it's just legally so. It's not actually so at all. It provides a list of factors that school boards could use in placing pupils in certain schools. And at the end of the day, all that had to matter was, well, if people in the community would be upset by a certain placement of a student in a school, then you have a reason not to make that placement. And this is up to you, local school boards, and your discretion to make that decision. So it was a way to avoid any kind of desegregation at all, and Shuttlesworth filed a case in federal court, but all the court said was, on its face, this is constitutional. If it's applied unconstitutionally, then we may step in at some later date. But all that to say, that case was not successful. Shuttlesworth then filed, or orchestrated the filing of, he was not an attorney himself, another case, Armstrong versus Birmingham Board of Education, which withered away on the docket of the federal judge for this district, who was there before Judge Pointer, Judge Seymour Lynn, for years and years and years. Ultimately, in 1963, Armstrong and a handful of other cases had finally, either through the adjudication of a trial court judge like Frank Johnson, who was willing to grant the relief that was needed in these cases, or through appeals to the what was at the time the Fifth Circuit Appellate Court, had resulted in that fall, 1963, was going to be the first year, the first semester, that a handful of African-American students had chosen to file these cases and attempt to get admittance to all-white schools. That fall, it was going to happen. There was Armstrong versus Birmingham, Hereford versus Huntsville, Bertie Mae Davis versus Mobile, and Lee versus Macon County, Alabama, which is where Tuskegee is. The response to that from the governor, who by that time was Governor Wallace, was to orchestrate a charade far larger in scope and scale than his infamous stand in the schoolhouse door at Tuscaloosa. Wallace used the state troopers as his sort of own personal shock troops, and he sent them to block every one of these schools that was scheduled to be desegregated by those students, and issued a number of executive orders to that end. And it takes every federal trial court and appellate judge in the state who's working on these cases to step in and to force Wallace to back down and to have these schools actually desegregated for the first time. In response to that reality, that is when Bob Chambliss planted that bomb beneath the steps of the 16th Street Baptist Church, as you all know. Desegregation through these court cases at that time was through a program known as freedom of choice. That meant that certain African-American students could elect to petition school boards to attend these then would be formerly all-white schools. Well, this would, of course, only be, as one judge said in one of these cases, a token of tokenism. You would still be left with all black schools and 95, 99% white schools, when the goal of the litigation had been, in the words of another judge, to get to just schools, to be able to look at a school system and have just schools or genuine integration. The Civil Rights Act is passed the following year, 1964. That empowers what was at the time the U.S. Department of Health, Education, and Welfare to initiate contact with school systems and to say, hey, have you heard about the Elementary and Secondary Education Act that provides millions and millions of dollars of federal money to your local school system? If you want that money, you need to present us with a plan to desegregate your system. Some school boards tried to comply with that. Obviously, the loss of millions of dollars in federal funding was not something to be taken lightly. But again, the governor and various other state officials step in to run interference. They wage a massive public campaign of intimidation against these local school boards. They tell them that this is unconstitutional and not to negotiate or do anything that the Department of Health, Education, and Welfare says. And so those efforts are limited in terms of their success as well. It's at this point that the case involving Jefferson County is filed. Stout versus Jefferson County Board of Education. Linda Stout was the student whose name fell at the top of the list of the handful who would petition the court to force Jefferson County to abide by Brown. That suit was joined in, as many were, by the Civil Rights Division of the Department of Justice, so sometimes the style of U.S. and Stout versus Jefferson County Board of Education. This turns out to be a landmark case. Actually, obviously it's very important here, but it turns out to be a landmark case, I think. In 1966, the Fifth Circuit ruled in this case that the guidelines that HEW, Department of Health, Education, and Welfare, there were guidelines they were putting forward to school boards to say, you need to, by the next year, have roughly X percentage of your pupils integrated. You need to look at faculty desegregation by the following year. And they were just benchmarks, to get you following some kind of reasonable path to actual integration. And people were arguing that these were unconstitutional, they're beyond the scope of the Civil Rights Act. It's the Stout case where the Fifth Circuit steps forward and says these are constitutional, but they also say freedom of choice as a method of desegregation was just a means to an end. Some folks thought, well, if we desegregate our schools, if we allow a few African-American students to attend these all-white schools, that's all we got to do. It's in this case that they step forward and they say, hey, if your freedom of choice program doesn't lead to actual integration, then you're going to have to try something else. Even if that something else is what they end up calling compulsory assignment, assigning students to schools so that if you look at a school system that's 70-30 white to black, most of the schools within that system ought to look roughly similar to that. And Stout is the first case where a federal court steps up and makes the determination that you might have to move beyond freedom of choice to get to actual integration. The other landmark case to come out of Alabama is the Lee versus Macon case. For it is in that case that attorney Fred Gray makes the case that, hey, Governor Wallace and these other state officials, they've been using a tremendous amount of power over local school systems to prevent desegregation. And then the Justice Department gets into the records and sees, oh, even beyond that, the State Board of Education and the governor, as president of that body, they exercise all kinds of daily control over these local school boards. It is clear that they have power and control over these local boards. Attorney Gray says to the federal court, why can't we make them use that power to actually desegregate rather than to prevent desegregation? And so he petitions the federal court in Levy-Macon for a statewide ruling that would take every school system in the state that was not already under a court order, like Jefferson County was. Every school board that was not under a court order in their own case, and put them under the supervision of the court in the Levy-Macon case. And that turns out to be 99 school systems. This is the first time that it ever happened. And in fact, Judge Frank Johnson, it's a 3-judge court that hears it because it had to do with state law, but Judge Johnson was the judge who really administers this thing. No federal court had ever used this kind of injunctive relief on a statewide basis, where the court would oversee for years and years, literally still now, to make sure that school systems present, as Trish was talking about, a plan to become unitary, but for the court to oversee that through one case for 99 systems, with the Department of Justice assisting and with the attorneys for the plaintiffs assisting and with HEW assisting. But it had never been done on a statewide basis, so the court would oversee that process into the 1970s rather, and eventually, one by one, those 99 systems would be actually made parties to the suit temporarily, and they would finally, once they had put forth a suitable plan, oftentimes they refused to put forth any plan, and it was up to the Justice Department attorneys or the plaintiff's attorney to present one that was suitable. Once they had done that, they could be put under a terminal type order, and then their case would be transferred from the 3-judge court in Montgomery to whatever district court, be it here in Birmingham or down in Mobile. Then a single judge would oversee that, and some of those judges are still overseeing some of those cases. It's not just Stout versus Jefferson that's still open. There are, the last time I looked at a list, the data was from 2014, but there were 46 systems or so. Attorney Colvin or Dr. Rush can probably tell us.
Drop off.
What's that?
We've had a few drop off.
Okay. So the number has come down from there a little bit, but yeah, there are, suffice to say, dozens of systems that are still under that court supervision. I know I'm running short on time probably at this point, but in 1968, the Supreme Court hands down another decision, not nearly as well known as Brown unless you work in the fields that they do. I see a hand up for the questions. I'm sorry.
Yeah, if you have a question, raise your hand and you can write them down.
I know, I'm used to just answering the questions too. It's like, right.
Green versus County School Board of New Kent County in Virginia. This is a landmark case because it's the Supreme Court stepping forward and saying freedom of choice as a method of desegregation is only acceptable if it works. If it works to eliminate what you rightly characterize as the dual school system, the racially dual school system. If freedom of choice is not working to affect that, then you need to move forward to some other method of desegregation, even if that's compulsory assignment. Of course, courts already made that determination in Jefferson, in this case, and in Levy-Macon. So what Green is, it's a Virginia case, it's a landmark Supreme Court case, but know that it's the 2 Alabama cases that really pushed the Supreme Court into making a judgment on that and embracing the thrust of these 2 cases coming out of Alabama. The result here in Jefferson County for about 2 years was widespread non-compliance, heeding the call of Governor Wallace and Albert Brewer, who would be the governor both after and before him. These parents would take their children just to the school of their choice, and they begin adopting freedom of choice as this ironic mantra for something that they want. The title of my book is The Politics of White Rights, and freedom of choice ends up being one of those rights to which these folks feel entitled. And I say ironic because it's something they've been fighting against for 20 years almost at that point, and now all of a sudden when you're threatened with genuine integration, well, we want freedom of choice. Because that allows us to maintain tokenism. That allows us to maintain all black schools and 95% white schools. So there was a time there for a year or two where there was, you had a school here in Jefferson County, say in Adamsville or Graysville, that was scheduled, a former all-black school that was scheduled to have an integrated student body, and it still got only black students, and all of a sudden, down the road, there's an all-white school that has 600 more students than it had the semester before, because rather than go to the integrated formerly black school, all the white students scheduled to go there just went to the nearest white school, the school of their choice, and again, being encouraged in this by the governor and other state officials.
And I want to interrupt you real quick in case you want to sip your water, but also it's important, we started with this premise that everybody understands why Brown v. Board was necessary, but just to take like one step back, schools in Alabama were incredibly unequal. All black schools were, just in terrible shape, old textbooks. Teachers were great. I mean, the teachers were not the problem, but the facilities and the access to new, fresh textbooks or, that kind of thing, it just wasn't there. The opportunities weren't there. The schools weren't open as long. There were just all of these inherent inequalities. And so white children were just given lots more opportunities to get a great education. Yeah. So that's why, it was true. It's still hard to find in the history books today. Yeah. When you look up in the history books that are in our kids' classrooms right now, you don't really see the pictures of the really horrible schools that black kids were forced to attend. You just have this idea that, everybody wants to go to school together. But it wasn't just that. It was like a real necessity to give black children more opportunity.
And I should say, it was pointed out to me when I got here earlier that the League of Women Voters of Greater Birmingham is in the book. Attorney U.W. Clement, who became a federal judge, was speaking to this august body at one point, and he makes the case, hey, it's not exactly about just throwing white and black students into a school or into a room together, it's about equal educational opportunity. Regrettably, later the Supreme Court says equal educational opportunity is not a right that we have. And so in the 70s and 80s, and you guys can speak to this maybe, there are limitations on what you can do to bring about equal educational opportunity. But just one last thing, and I'll sit down and shut up. As with the initiation of desegregation to begin with, moving beyond freedom of choice and trying to effect genuine integration leads to a massive increase in white flight. And that takes a couple of different forms. Here in Alabama, in rural areas, that meant to the segregation academies. And in metropolitan areas like this, it meant to the suburbs. Some of the suburban municipalities here in Birmingham had already severed, seceded, splintered off from the county system by the time they were hit with the court order in Stout and Mountain Brook, Tarrant, Bessemer, Fairfield. And I wanted to mention this because of what recently had been going on north of here in Gardendale. Hueytown, Pleasant Grove, Homewood, Vestavia, and Midfield all attempted to sever off after the court orders. And so they end up actually drawn into the litigation in the Stout case, having to satisfy certain factors to be able to become independent school systems, or in Pleasant Grove's case, they were not allowed to. Have they since, or are they still part of the county?
No, they're still
Pleasant Grove.
So this is a process that Judge Lynn oversaw that got thrown, I guess, into Judge Pointer's lap. Did he take Judge Lynn's place?
No, he just took the case.
Okay.
Yeah, Judge Lynn.
Who was getting old at the time, I guess.
Yeah, Judge Lynn was still on the bench when I started as an attorney in '95. So, okay. But he was not young.
Right. Well, maybe this is a good opportunity to pass it off. I just wanted to mention the splinter system issue. And also, too, this is when Hoover was incorporated.
88, 89.
Yeah, the city.
Oh, the city.
Yeah, and as you mentioned, Hoover remains within the county, but I think a lot of people don't know, and it should be mentioned, William Hoover, when Birmingham was first threatened with desegregation, attempted to open segregation academies in the city of Birmingham and West End, and that didn't work out for a variety of reasons. And instead he turns his attention south. For William Hoover was a rabid segregationist and an anti-Semite who was in an organization known as the National States Rights Party. And so I think he envisioned himself as leading a sort of Boer-esque great trek into the lily-white suburbs. And so it is interesting, though, that Hoover did indeed remain within the county system for so long. And again, because the Stout case had been filed, these systems, anybody that was considering that was going to have to satisfy certain factors, which was going to be the case with Gardendale, but as you guys probably know, the 11th Circuit stepped in and overturned the trial court order in that case. I've probably gone on far longer than I need to, and hopefully you guys will have some really good questions where we can flesh this out a little bit more. But
I really appreciate that. Thank you.
thank you.
I feel well schooled. I mean, to boil that down into a 20-minute period is asking a lot.
Yeah.
So you did a great job, and I appreciate that. And then now we move forward maybe a few years, and Mr. Colvin can tell us, kind of like what happened after that period and where we are. I gave him sort of a list of things to think about. But
I'm looking at it right here.
yeah, that's good, 'cause I don't have mine, so that's great. But just the idea of like what are school systems. So 45, I think Mr. Colvin and I decided somewhere between 40, 45, 47. It's hard to tell with some of these old cases if the desegregation orders are still in effect, because some of them are just kind of sitting there and nobody's really done anything with them. But they sit open in case somebody has a problem, and then you can go back in front of the judge easier, right? It's easier if it's still open. But 47 is a lot, y'all. I mean, we have 137, 138 school districts once Gulf Shores comes on. That's a third of our school districts are still under desegregation orders. And some of them have just chosen not to pursue unitary status because it's expensive and you have to hire lawyers. But others, I don't know what their motivations are for not trying to obtain unitary status, because it's a lot of work. I mean, this is, I won't point anybody out, but, Hoover is going through this work also. And it's a lot of work to talk. We have a judge here, Judge Madeline Heikkila, who is serious about this. And she is not, and sometimes judges in past generations were kind of like, you want to do that? Sure, that's fine, you go right ahead. And nobody really looked at the long-term implications of what a school system was trying to do. With that, I'll be quiet. Mr. Coleman.
Okay, thank you, Trish.
Chris, when you introduce your panel, can you call their first name and last name?
Yes.
I'll introduce again. How about that? That make it easier?
Does
that work?
Yeah.
Okay, so again, I'm Whit Colvin. I work with a law firm here in Birmingham, Bishop Colvin Johnson in Kent, and I would have loved to have sat there. I could listen to this all night. I really could. This is the world that I operate in. I did not graduate from law school to become a desegregation lawyer. I don't think one does that, right? I went to work. My firm actually has represented the Jefferson County Board of Education for, I don't know, I used to say over 40 years, but now it's probably 50 or 60 years. And so my predecessors were actually the ones fighting fighting not to desegregate, right? Yeah. Back in the early parts of the case. And so I graduated from law school in 1995, and like many in my generation, knew about desegregation largely because I went to Vestavia Hills High School. I went to the Vestavia Hills City Schools, and we had kids that went to school with us who didn't live in the city. And so there were kids from Oxmoor Valley, and that was part of Judge Pointer's solution for Vestavia Hills, is because there were no African-American students in the city of Vestavia Hills, he essentially brought kids in from somewhere else in Birmingham where there was an African-American population, and those were the only kids that rode the bus, and there were other African-American kids in the system, but not many. So I knew about it from that context, but like Trish said, we don't learn about this in school, or we didn't learn about this in school. Of course, when I was at Vestavia Hills, we were the rebels, formed post the Stout case, right? We were the rebels, and our symbol was the rebel flag, which was flown at football games. I can remember it being at one point a helicopter flying in with a giant rebel flag on it.
They played Dixie.
It played Dixie. We had a rebel man, which that community had until recent years still used that. And so that was my context. You know, that's what I sort of knew, but never gave it a whole lot of thought. And it's just because we didn't talk about it. It wasn't until a little later that community really started talking about it and kind of coming to grips with some of those things. As I understand it, I do not live there, but my parents still do, and so I follow things because that was where I grew up. After I graduated from law school, I began working for school boards, and especially Jefferson County. And my partner, the Stout case had sort of been on a shelf for a while. And I think the attitude of that board, and many boards still to this day, are, you know what, as long as it's going to be really hard to fix, it's going to be really expensive to fix, and so if nobody from the government's pushing it or anyone else, then we'll just keep on doing what we're doing. And I think that's the prevalent consideration for a number of the other systems that are still under order but not active. So my partner told me that we had an issue that came up. We still had to get permission to do certain things like build schools and change zone lines, because those zone lines are set by court order in systems that are under a consent decree, and we were. So there was a community where we wanted to move some zone lines, and the United States was coming down, the Department of Justice, and the NAACP Legal Defense Fund, which is the other group that I work with, a gentleman named Norman Chachkin from there, who became not only was a colleague but a dear friend. And so my partner said, just go to this hearing. It won't be any problem. The United States, they handle everything, right? And I go to this hearing, and it was before a new federal judge at that point, Judge Inga Johnson, who is on senior status now in Florence. But I went in there, and it was like I walked into a buzzsaw. The first thing, even though the United States was supposed to, quote, take the lead, Judge Johnson said, all right, Jefferson County, tell me what this is about. And so it was game on. And I was all of 27 years old or something. Talking about something that I had not much context for. And at that point, I inherited the Stout case. And which was okay, because what I found was that, and I've handled the Stout case now for over 20 years. The Stout case led to other things for me. It led to greater legal understanding, but it also led me to a greater understanding of other issues as well. And my perspective really on education changed because of it. I found, and I'm going to get corny, this is my client, so I can do this. We work together all the time, but I've just I've come to realize that even though we're looking back on things that have been there a long time, but the desegregation cases have been a real blessing for me, personally. I have made friends and have learned things and have looked at school issues from a perspective that I never would have had to before. And with my clients even, and I have a number of clients that are going through this, and I do represent other school boards that deal with these issues. One of my sort of conditions of me helping them is that, we're going to do things the right way, and we're not going to be made to do anything. And we said this the other day, Orletta and I were talking to a school board, and we said, these cases, it's not about obligation to us, but it's about opportunity. And the opportunities, and it sounds so strange, but for both Caucasian students and for African American students, what the desegregation does is it makes school boards think about these issues and talk about these issues and structure themselves so as to address issues of equity in a way that they wouldn't do otherwise. And you don't have to. And in part, as Dr. Bagley said, it's because once a school board is released, once the dual system, the de jure system, is dismantled, and you get unitary status, then the bar goes from here to here. You have to show major intentional constitutional violations and equal protection violations in a way that you don't have to in a desegregation case. It's incredibly hard. The Department of Justice does have some enforcement authority under Title VI, but they don't use it much. And so what you see then is in those sorts of attempts to undertake efforts which are a bit like desegregation cases, post-desegregation are almost impossible. The Supreme Court has made it almost impossible. And so, in a weird way, the districts that I represent that are still under court orders, it gives us an opportunity to do some things for kids and talk about things that we frankly wouldn't be able to do otherwise. Because then we would be violating the Constitution by considering things like race, which you're not supposed to do. So we consider opportunity, not obligation. So how does this work from a practical perspective? Just in case any of you are wondering how it works. Trish is wondering, of course. The rest of you are like, just put the professor back up. I will say this as an aside. One of probably the folks that you write about in your book, I've had the opportunity to work with almost all of them, either in the Knight case or from Saul C. to Fred Gray's kids, Stanley and Fred Jr., to Ernestine Satt, who was Fred's partner, who I talked to once a week, to UW Clement, who was on the bench and is now back a part of the Stout case representing the plaintiffs. And it's been a real joy. There's so much history there and so much perspective, and so I've learned so much from them too. So where are we? Is that a fair question? Where are we? We talked about, and just as an aside, y'all, I also did work the state case that Dr. Bagley was referring to, the Levy-Macon statewide case. One of the first things I did after the Stout, my first initiation into Stout, was to go help the State Department of Education with their final two statewide issues, which were special education and facilities. And we obtained unitary status on both of those factors. And so the statewide issues are done. So from a statewide perspective, the courts have given their blessing and have said, from the State Board of Education, the state education system, you are not operating in a way that continues that dual system anymore. That was quite an experience too, because it was a bigger umbrella. So I represent the Calhoun County Board of Education in their desegregation efforts, and they are under a consent decree, which is we're filing a motion for unitary status hopefully in the next month, something like that. It's drafted and it's being circulated among the parties. It took two modern consent decrees, a whole lot of work. In cases like that, you get results in some areas. In some areas, you may not get all the results you want, but the efforts have been expended, and it's changed that school system.
And I want to jump in, because you and I are real familiar with all this stuff.
Yes.
And I'm thinking, okay, what questions would I have if I didn't use these terms? So when he talks about the work that needs to be done, you're talking about work in about 6 areas, right?
We call them the green factors, which is from the case that Dr. Bagley described, Green v. County, New Kent County is what we call it. And there are either 5 or 6, depending on how you say it, but they're really 5 because one of them gets put together. But what they do is they look at student assignment, which involves the zone lines, the kind of things that we think of in terms of attendance. And I always have to recollect, Orletta may have to help me, faculty and staff, which is our personnel, another big one, extracurricular activities, which transportation, and facilities. Discipline is what happened is after that happened, so that was the framework, and that was all we looked at. And in a later Supreme Court case, the Supreme Court also came in and said, you are also supposed to look at what we call quality of education. That can be a factor that gets looked at too. And quality of education often involves discipline. That's the big one. Discipline, and particularly disparities in discipline in schools. And that's something that we see. So that's the framework. When a court is looking at and analyzing whether a district has done what it needs to do, it looks at progress in those particular areas. It's the green factors.
And progress means that you're not treating one race differently than the other. Well, particularly
It does.
you're not treating African American children poorly, and like disciplining them more harshly, or putting them, or assigning, this school is going to be racially identifiable. We've got a lot of black children here, and we're keeping this school over here for the white kids. So that's what progress means, is you're not doing those things anymore. Right?
Or you have mechanisms in place that are designed to keep from doing those things,
Okay.
for example. So it's not in this day and age, it's not a quota system. So it's not like you've got certain marks, and once you hit them, you're cool. And they were, our court cases were being operated that way at some point. And those were what we call them singleton ratios. Just to get kind of technical, it's where you're plus and minus a certain percentage. Because what you're doing is you're comparing your programs and activities of the district as a whole, or of each individual school to the district as a whole. So, for example, when I started in Jefferson County was about 80% Caucasian students and about 20% African American students. And so, when you look at the student assignment piece, the first analysis is, okay, well, what are your student populations at each school? And it's supposed to mirror, the populations of each school are supposed to mirror the system-wide average. The farther apart you are from that, it means that you haven't done what you're supposed to do, or you have what we call racially identifiable schools. And the bracket for racially identifiable schools is different for different courts, but it basically means you've got your majority white schools over here and your majority black schools. If you're operating, let's say, in an 80-20, then you use that singleton ratio and you figure out, okay, what's racially identifiable and what's not. In Jefferson County today, it's a different school system. And it is more like 52.7% African American, and probably about 40% Caucasian. And then you have your other races kind of in the middle. So what you'll look at, and this came out in the Gardendale case, that if you look at it, the spectrum looks a little different. You don't have you actually have a system where if you use the singleton ratios, most of the schools are racially identifiable in some way. You have very few schools that are close to the system-wide average. And whether that's attributable to residential patterns or whether that's the zone lines are the same. Zone lines have stayed the same largely since the early 1970s. They haven't changed much. So what that means is people have moved, or perhaps schools have been built and people have gone there. So there are a number of things that we do to try to address that and to try to get more integration in schools. And we've got lots of techniques, and it depends on the particular situation. You look at things like transfers, which we've seen in a number of places. You have magnet schools sometimes. You can have controlled chores or pairing. You can have rezoning. And, obviously rezoning or redrawing zone lines, which we did in Hoover, 3 years ago? Yes, it went into effect in Huntsville. Rezonings have a real effect on student populations. Now, let me say this. The difference between, say, Jefferson County and Huntsville or Hoover, Huntsville, part of the reason that Huntsville had the comprehensive rezoning that they did is because they went ahead with a school reorganization and construction plan kind of early on, maybe possibly without really consulting with the government before they kind of made decisions about where things were going to go. And so when you do that with the courts, sometimes you end up with a little more difficult row to hoe than if you let folks in on the front end of the planning. In Hoover, of course, Hoover's schools look very different than Jefferson County's. You've got 2 high schools, and they're unified high schools. So all the kids go to those 2 schools. And those 2 schools look, they're not exactly alike in terms of racial composition, but they look a lot alike. Similarly, at the elementary levels, now at least, you've got schools that, with very few exceptions, most of your schools here look a lot like the system-wide composition. And that's the goal. That's what it's supposed to look like. With the exception of some outliers like, say, Greystone, which is it's geographically isolated in a way in the city where so you have that, which is sort of on one end of the spectrum, and then you have say Green Valley, which is maybe just a little bit higher in terms of African American population than the mean, but not so much so that I wouldn't describe it as racially identifiable because it's not that far away from the system-wide average at this point.
And I'm going to step in.
Yeah.
You gave me a perfect in because I went to Green Valley from
Right.
1st through 7th grades, and so did Emily. Emily went to school with my children. It was really exciting to see you here.
Well, my dad owned the Putt Putt, which was right next to Green Valley.
I didn't know that.
I
That
know.
was a
See,
big
you
deal.
find out new things, right?
Wow.
That's where I played video games growing up. So.
I might have seen you there, although
You
could've been a few
very
classes.
well may have.
Well, I'm going to, just to keep things moving,
Let's let Orletta.
she can tell us on the ground what that work really looks like. Because,
Right.
so Whit's given us, Mr. Colvin's given us a framework of kind of what it means when you're at the board level, and you got to answer to the federal courts, you've got to answer to, there's some reports, you may want to mention that. You have to really think about these things, and if you don't have to think about them, I thought you put it very fairly. You might not. If there's not somebody looking over your shoulder saying, think about that.
And let me say this too before I turn it over to my colleague and dear friend, but we talked about the number of school districts that are still under desegregation orders. And what's happened is you've got a bundle, about 25, almost 30 districts that were kind of dealt with in that period right after Dr. Bagley told us about, which is the mid-70s or so, where you've got these court orders where I call them kind of a go forth and send no more order, or a suspended animation order for real. And a lot of them say, you guys are operating in a unitary matter, or unitary manner. Now, to get unitary status, you have to go through a process of notice and hearings, and you have to go through a longer process with the court. But they didn't really know that then. So a lot of the judges, they would just say, okay, well, you did what you're supposed to do under the 1971 or 72 plans, which there are a lot of them, some of them 74, but in that early 70s, our school districts were put under decrees or plans, and they would work them for a while, 3 to 5 years, and they'd go in and they say, we did what we were supposed to do, and the court would say, you look unitary to us, go forth and sin no more. Okay? And the orders, they're short, they're a paragraph long sometimes, and they'll say, okay, we're going to take this off the active docket and put it on the shelf. And so a number of these school districts are on the shelf and have been since the mid-70s, as in probably 25 of the 25 to 30 of the number that we talked about. And so they're just kind of sitting there, and Trish, you put it very well when you said they just kind of sit there until something comes up. And you have that every now and then. Shelby County's a perfect example. Shelby County had an order like that, and there was a case several years ago with an employee, and the board itself actually used the desegregation order as kind of a defense to what they did. And at that point, it reactivated, but just for a little while, and then it got put back on the shelf. The districts I'm dealing with most directly, the Jefferson County Board, Hoover, the Calhoun counties, they are actually under active desegregation orders, active supervision from courts. And what that means is we have to file reports, and we have to answer to the court, and we have to get permission from the court to do to make operational changes that fall within the scope of the plan that was given to us. So even though we do have a large number still in Alabama, and the Department of Justice is begin focusing on those, because they realize that, it impacts business, right? It impacts reputation. It impacts us as residents of Alabama. When you say we have almost a third of our schools, which are still under court order, so what happens with those cases is when they get reactivated, the justice will come in and they sort of do a quick review, and if things look okay, then they'll actually go have a hearing, and as long as there's no problems, that path to unitary status or full unitary status is much easier and shorter than the path to unitary status for districts that are under active supervision. And she will tell you all about what it feels like to be under active supervision, because we are living that every day.
Thank you, Mr. Golden. This is Dr. Orletta Rush, and I'm going to just let her take it over.
Good evening. I'm Dr. Orletta Rush. I've had the pleasure of growing to know Trish, and we've become really good friends. Work well with Whit. This is going into my 21st year in education, and I kind of stumbled into DSEG, It was always a passion of mine, but I didn't know it would actually bring me full circle the way that it is. I began my career in Opelika City teaching. So I actually taught there for years before my husband's job relocated us to Birmingham, and I moved here with my husband, and I took a job with Jefferson County teaching 4th grade. So I kind of went through the entire system, assistant principal, principal, and then on to the school board. When my first stint as an assistant principal, that was during the No Child Left Behind era. So I had the pleasure of being an assistant principal in about a 70-30 racially balanced, or if you want to say racially balanced, 70-30, 70 Caucasian, 30% African-American school, where you were having a large percentage, usually between 75 to 100 students, that were being bused from No Child Left Behind over to another school at that particular time. And that was my first kind of stint as an assistant principal. That pretty much changed my life the remaining of the time. I learned a tremendous amount just being there to be there and be advocates for those students and being advocates for students within the building, but also to make that transition for those 75 to 100 students on a day-to-day basis, being bused from one school to another school simply by their parents' choice wanting a somewhat of a better education for them. And that kind of started me into my path. And for years I'd heard my parents who integrated.
And the kids who were being bused were largely
African-American students that were coming from within our same school district. So it would be maybe like a 45-minute bus ride that could take them, over and bring them to another school. So that kind of started me there. Like Whit said, you kind of sometimes get your passion from growing up. My parents actually were the graduating class for Opelika High School that segregated that high school in 1971. So I remember growing up hearing those stories, and it was kind of a fascinating thing to me, but never knew that it would bring me full circle to where I am today. However, like I said, worked in many schools, many different populations. I've been at a school where I've had high ELL population. Most of my schools that I've been principal, worked in as a teacher, high African-American population. And it was always a passion of mine to make sure that all students, not just African-American students, but all students had equal opportunity for a great education. And I think Jefferson County gives that opportunity on a daily basis. But that was something that we really wanted to work hard at. My first encounter working with WIT, again, like working with the federal government, we're under a DSEG order. And we really can't make a lot of moves at all without their permission. If we want to move a zone line, if we want to close a school, if we want to move just a little bit of group of students, like I had the pleasure of working with at Brighton Middle School, if you want to move those students to go to another school for a better opportunity that you can't really offer them at that school, you have to get permission from the federal government. So that's how I ended up working with WIT as a principal. We looked at what we could do to make a lot of changes, and that was my first encounter where, coming up with a decree, approaching the federal government, and seeking permission to be able to do the things that we wanted to at Brighton. So that was when we moved our middle school from Brighton, which was your 7th and 8th grade students, to matriculate through Hewittown Middle School and Pleasant Grove Middle School, which was kind of off the back of the stout order that gave a little bit. It was kind of the end part that was left with the stout order for the Brighton area where those students were. And so that kind of got our work started. Went through that and then had the opportunity to...
Yeah, because Brighton, y'all, Brighton, I can't help it, but Brighton is fascinating. Brighton is like they had sort of a super position, right? Because students at Brighton, Judge Pointer found that because the opportunities were so disparate for them, that they actually could choose to go to any school in the whole district.
Yes.
So they got to choose. It's like super choice. The Brighton kids could go anywhere they wanted to in Jefferson County, and nobody else could do that in the whole system.
And it's still that way to this
Still that
day.
way to this day.
So that was one of the things that kind of got us started. Once I did that for a little while, stayed at Brighton for a couple of years, and then the opportunity, we had this fabulous superintendent that came our way, and like I said, this DSEG order had been sitting on the shelf, and it had kind of got kicked up a little bit when we went through our little stint with Gardendale, and we decided to have the bright idea that we wanted to do what was right for all the kids in Jefferson County, and let's put this to bed. So that's how it blossomed into, now we're going to move forward to seeking what unitary status is. And basically, like what Trish said, we're looking at showing the federal government that there's no reason that we need to be up under this DSEG board anymore. We're doing what's right for children, making sure that all opportunities are equal for all kids within our school district. So it is a lot of work. It is a ton of work, but it's the most rewarding work regardless of how much it is. There's a lot of days that you don't know if you take 2 steps forward and then you take 6 steps backwards because you think of all the things that you're trying to show that you're doing, but it gives you an insight within your system to see how so many things that you are doing great and how there's still so much work to be done. So it's one of the most fulfilling work that you can ever work with, but at the same time it is just exhausted. It's very easy to see that you want to make all of this right. It seems very simplistic. We just do what we do for everybody, but it's so much easier said than it is.
What all we have to do, like what we're thinking about doing.
Yes. So what it is now, what you have to do, Jefferson County has 57 schools, which are so many different pockets and so many different cultures and so many different everything. So you have to try to figure out how can I make this right for all. So, we toyed around with so many different ideas, and we came to the point where we're looking at doing things, looking at limited choice within areas. We're building large, new, beautiful elementary schools, and we want to give an opportunity where parents can see within a little small pocket. You may have one huge focus that you want to focus on, whether it's STEM, whether it's fine arts, whether it's going into leadership. We want to start it at an elementary level where it can kind of blossom into the middle school area and then blossom into the high school area where we're turning out these pupils that have had an opportunity to be in a very diverse area that are focused on things that will carry them a lifetime. So that's a huge step for Jefferson County. That's something that we've never done before in our entire existence. And I mean, sometimes it gets overwhelming just to think about some of the things that we're putting down on paper and we want to do. But we're looking at just kind of starting small to turn that ship, which is really huge, and then eventually evolving it into the entire school district. So it's one of those things where we're seeing where we need to make changes. We want to make changes. We don't want to uproot students and just move zone lines because that causes chaos. And we don't want people to be at dismay because that's not going to be what's best for students. So we're looking at ways to be able to offer opportunity for the students to be able to be in diverse areas. If you're looking at a STEM academy and that's what you want, and you have normally gone to this school, but guess what, it may not be at this school. You may have to go to this school where there are a lot of brown kids now. So you're going to be down there with them, and you know what, that's okay because guess what, that's the real world. And that's what we're trying to teach our students in Jefferson County, starting small in pockets, but then making it where to elevate into the entire school.
I'm going to help 1 second, too. Just think about this, y'all. Think about this. Think about what would go into a school district. Everything that goes into a school district. ingredients that go in and make that gumbo, right? From personnel to student discipline,
Yes.
to where kids get placed in classrooms, to which buses they ride, to how new their school is, to how well it's maintained, whether they have LED lights in the ceiling or not, whether their air conditioning is, Jim.
Yes.
The gym is air conditioning. Think about taking a look at everything, all of it, and take a step back, and she has to look at data. And you take data and you analyze it and you say, is there equity here? And guess what? In most places, you can find areas that are not equitable, right? Do we have as many African American children in AP classes as we do Caucasian children? What do you think? Anybody want to guess? No, right? Advanced math? No. Do kids have the same sort of access? What about discipline? What do you think? Who gets disciplined? And she did her dissertation on this. Who gets disciplined more than anybody else in schools? African American males, right? So we can just say, well, great, Trish wrote about this. She wrote a wonderful article that I've had discussions with lots of people in education about our failing schools in Alabama. And she said, guess what? Guess what our failing schools look like? What do they look like? Yes. They're poor and African American majority schools. And here's what we did, and I'm on my soapbox for just a second. She writes this article, and everybody says, yeah, that's what we thought. And it goes in the stack with everything else. Our job is to take data like that and say, and not say because we want to. We do want to. We're required to do something with that. That's what a desegregation order gives us that we don't have in other places necessarily, right? We have to look at where our personnel are. And it's not just figuring out where they are, but then what are you going to do about it? What happens if you've got too many black teachers at this school and too many white teachers at this school? What are you going to do about it? Same with students. Same with discipline. We're rewriting codes of conduct. We're having to come up with innovative programs to get parents to want to send their kids to other schools and to create quality schools.
Yes.
You build schools in certain areas. We have to look at all of it through the lens of our case. And with almost 33,000 students and 56 schools and 13 different sort of sub-feeder patterns or districts in Jefferson County, can you imagine what that looks like? Some as different as Corner, which is in the corner of Jefferson County, very geographically isolated, down to Center Point, which is at this point almost 100% African American and higher poverty. And so guess what's getting compared? Both those schools are getting compared with each other. Okay? Very different parents, very different students, very different community, in lots very different cultures. One of the things that we have to do too, and this is what she does, is we have to make teachers understand each other's culture, right? And I had a speech today. It's a perfect example. Latino students. It's a sign of disrespect for a Latino student to look an adult in the eye when they're being disciplined. Well, where I grew up, if you didn't look somebody in the eye, it was a sign of disrespect. Guess what? We don't know that unless we learn about each other. And so that's a lot of the work too. A lot of it's messaging. There's so much that goes into it. I don't know how she does it, but that's why she stays so busy. But just imagine that sort of level of almost deconstruction and then reconstruction, and that's what a desegregation case is like.
I'll chime in here and say that Dr. Phil Raley, who's the superintendent of Opelika, when they attained unitary status,
Yes.
I guess this was right before everything started getting digitized, because he told me when they drove down to the district court in Montgomery, they literally filled up the back of a pickup truck with all of the documentation that they had to have to present to the court. And you can imagine Superintendent Raley and whoever else was subjected to having to help him carry boxes and boxes and boxes of documentation in there. And that's what that looks like. That's the level of scrutiny.
Actually, it is. I couldn't imagine. I can seriously imagine what they're doing, because I can just, from the transition of emailing and sending things out, it just becomes so overwhelming.
This hard drive is full.
I mean, it is completely full. You can never send enough data. I mean, we just finished a whole day today on from 8 o'clock this morning to 3:30 on a diversity training. Every school in our district was out down. They had representation, 5-member team at our board today, receiving diversity training from someone from Boise, Idaho, or ASCD, coming in, teaching us to work with different cultures. What is it to sit down with students that may not come from the same value as you have or look the way that you do, but we are expected to do the very best education possible by them. So, I mean, and that's something that Jefferson, we're in our second year doing that, and we do it 3 times a year for all of our staff members. So, trying to make sure that everybody has a level playing field and a level of understanding.
And I will say too, that work, to me, that like, I love the data, I love the reports, I do.
Come on.
And I can convert a 414-page
I know.
PDF pretty quickly these days into a spreadsheet. But that work, all those numbers mean something, right? So a few of the districts that are under desegregation orders have to file reports with the court once a year, and that's typically in October. And these reports are, I mean, that 414 pages, they have to file a report, Hoover does it too, that shows every teacher's, every period, and the breakdown, the name of the class, the breakdown of the population, black, white, and other. Yeah, I used to break down more, but
We have more. You haven't looked at yesterday's file.
you're right. Okay, good, that's exciting. But that's a lot of work. But you know, you can produce those reports and never look at them, right? I mean, you can just hit go. But Dr. Rush gets to look at those reports and say, what are they telling me? Because, you know, data really doesn't lie. You can play with numbers, but if the data tells you that 80% of the kids that you suspended out of school were black, but your population is only 30% African American, you need to ask yourself why. You know, I mean, and those are hard conversations, because a lot of times I had the opportunity to work with teachers last year in a Facebook group to talk about the disparities in discipline and the disparities in, you know, who do you refer for the enrichment classes, right? Who do you say needs to go to remedial classes, right? Teachers have a lot of discretion here. They're the ones viewing the test scores. They're the ones doing the pop quizzes. And so it comes down to each teacher has to be as incredibly fair as possible. And if you think that everybody's supposed to be like you know, we've all heard the whole, well, I could pick myself up by my bootstraps, you know. Well, I have 4 bootstraps. Not everybody has 4 bootstraps. And so, you know, I remember this from the Huntsville. You probably were listening in. There was a live feed of Judge Heikkila asking the then Huntsville superintendent some questions about AP classes, advanced placement classes. And said, you know, why do you offer, you know, no advanced placement classes at this particular high school that's, you know, 98% African American? And he said, well, those kids didn't sign up for them. And you could almost hear all the air get sucked out of the room, because she said, well, who's helping children prepare for those classes? What are you doing at middle school? What are you doing in elementary school to get kids ready for AP? How do kids know? And, you know, she just started shooting off the questions. It was really, I'm getting chills thinking about it, y'all. For me, it was really exciting. So just this level of thinking that, are we sure that all kids have the same opportunities? It sounds good when we say it. But, you know, what's actually happening on the ground, Dr. Rush has to make that happen. I mean, it's hard work. And thank you, Dr. Rush. Okay, so we can do a couple of things. It's 5:08. We have to be out of here by about 8:30. We can take a couple of minutes break, or we can go. I've got some questions. If anybody just wants to be excused, step out and come back in, that's okay too. Just go. Just go. Just go. Okay. So I'm going to. I've got a few questions. Does anybody have some more? So I'm going to take a point point of privilege and ask you one question that I hear sometimes, and that is, are federal desegregation orders even needed anymore? You know, I get this question, like, do we really need this kind of oversight? Have they outlived their usefulness? I kind of think I know what y'all are going to say, but, you know, in just a succinct, 30, 45 seconds a minute, tell me, I'm going to start with you, Dr. Rush. Do you think that these federal desegregation orders are still relevant today?
I do. I really and truly do believe that they're relevant because they hold us accountable. A lot of times, just as a human race, sometimes when there's no accountability, we unbiased do things. We're not conscious of what we do sometimes. But when you have an accountability in place that holds you responsible for something that you should do automatically, but it still holds you responsible, that makes a big difference. So yes, I think it is very relevant.
I appreciate that. And Mr. Colvin?
It's probably not, I'm not sure I want to answer the question directly.
Okay.
Given that I've got a number of those cases in front of federal judges and whatnot.
Oh, that's a good point.
But I will
You
say,
need to recuse yourself.
no, but I will say this. But I will say this, that from a, my job is to help the districts with whatever problems I'm presented with, and not just that, but to try to sometimes take lemons and make lemonade or whatever. And at the end of the day, my job is really about helping our district serve kids better. I mean, the magic of education is in the classroom. It's when kids get to learn, and from professors and teachers, and that, I mean, it's magic, right? That happens. And so my job is to support that in whatever way I can. So let me say this, that I take what I get, which are the desegregation orders that I have to handle, and the districts I work with, we approach those as if, yes, there's work to do, but we don't talk about, quote, getting unitary status, or we got to get out from under this federal court order. We don't use language like that because it's not an obligation for the districts. We look at it as an opportunity to do the right thing. And if we're doing the right thing, the unitary status will come. So we don't focus on the act of unitary status. We do what we need to do to get there, but we're doing it because it's the right thing, not because we're being made to. If we're being made to, we're no different than those who, that the National Guard came in and made do things, right? That's not why we're doing things. It's not why the districts, it's not why Dr. Rush is doing them. So the boards I work with, we focus on that and choose not to focus on whether it's needed or not. It just is. If it's in place, it's our job to follow it, regardless of how we got there. And so we might as well be happy about it, right? You either be miserable or happy. I choose to be happy.
Can you tell that or what? That attorney, he smiles a lot. It's a little suspicious. But, and Dr. Bagley, do you have any thoughts on that?
Sure, of course.
This is actually a question best left to
I don't
our
know.
professor on the panel.
I should do what I did. I presented the archives down in Montgomery on the Levy-Making case specifically, and was, I don't know why I was blindsided by this. The very first question was, so what do you think we ought to do now? And I was like, I'm a historian, I don't make policy. I just tell a story. I don't offer, no. So it's made me think a lot about that since that time. That was several years ago. But a couple of things. One, you don't always have a Attorney Colvin or a Dr. Rush who approaches these things in this way, particularly, like you said earlier, think about all the systems that are either not under an order or even that are, but it's inactive like you were talking about. You're not having to think about these things as deeply as you all are having to think about them on a daily basis. I think that's tremendously important in a lot of places because there's not a guarantee you're going to have people that approach it with the kind of attitude that you guys do. In addition to that, I would say there are those places that are under court orders and that attain unitary status that also don't have these forward-thinking, dedicated people. And studies have shown that the minute that the court orders are gone and the supervision is gone, that they resegregate. And it's happened in this state, too, in certain places. And so, yeah, I think it absolutely is not only still relevant, but necessary. Very important.
Well, thank you. I felt felt like that was a bit of a setup, but, it's accountability, right? And if your community, Alabama didn't show that it was very accountable to doing the right thing by all kids. Local governments, there were a few that really did well, that sort of jumped up and said, yeah, we're going to do the right thing. Okay, now I'm going to get to your questions, and there are a lot of them, and there are a lot of words, and I got another one. So I'm going to see if I can pick one real quickly. Let's just ask this, because I do get this asked a lot, and it just came in, so it's a great question. Did this ever, and does it still, ever apply to colleges and universities? I think it was community colleges, right?
Yeah. In the Levy-Macon case, community colleges and trade schools were dealt with very directly in much the same way that the K-12 schools were. And so that looked not identical, but very, very similar. That being said, when certain cases were filed to attempt to deal with, say, I think it was AUM and UAH, there were cases filed in an attempt to deal with those schools in the same way. Even Judge Johnson, who is known as a great defender of constitutional rights, made a number of famous decisions to permit a lot of demonstrations he may not have personally agreed with even. But Judge Johnson said in that case, well, college is a different animal, basically.
And had its own case,
yeah.
as Dr. Bagley mentioned, the case, which is not exactly the same, but is
well,
it's
and
very,
you know
very
what?
similar.
I won't take up all the time because you are probably more familiar with it than me, but the Knight case was filed in the 80s.
It's in the 80s.
Yeah, and Knight versus Alabama was an attempt initially to hold our higher institutions of higher learning accountable in the same way, but it took an interesting turn eventually, and the plaintiffs contended at one point, due to Alabama's property tax structure, that African American students did not have the same opportunity to attend college. Ultimately, that leads to the filing of another case because the court said, well, that's a different issue for another day, and so the plaintiffs filed the Lynch case. Taking aim at those lid bills I mentioned earlier, which, in a nutshell, because a lot of the property in the Black Belt is owned still by white people, and the schools, because of white flight, desegregation economics, have become entirely African American in many cases. There were lids or caps put on the amount of property tax revenue that you could get from certain kinds of land, because a lot of that land is timberland or agricultural land. And so Alabama's property tax revenues are dead last in the nation, and I don't even think it's close to whoever's number 49. All that to say, these issues have been litigated, but college has tended to be a different animal, and you can probably speak to this more authoritatively.
Well, I represented the University of Montevallo in the Knight case, and because the University of Montevallo didn't have the history or the problems that some of the other schools had, we ended up with a pretty. The case was ultimately resolved and dismissed. But we ended up we were sort of never the target of that case, mm-hmm. So we were on the periphery of it, but got to watch, and it was very involved, but it's a different sort of analysis, but the same sort of kernel of constitutional concerns, mm-hmm. I suppose, in it. And, but yeah, it was a big mess. If you can imagine all of the time and money spent by all the institutions of higher learning in the state of Alabama, everybody in one case together, required a special master, and a judge that was in Rome, Georgia, where you would have to drive over there to hearings, because I don't know exactly why it ended up there, but he ended up with the case, and so yes, there's.
Well, even just as recently as this past year, there was a case, was at Harvard, where the East Asian students contended that they were at a disadvantage if Harvard was trying to diversify its student body. Right.
We have not gotten an opinion in that case, but interestingly, you may not be aware of this, Dr. Bagley, Homewood, the city of Homewood, just sued the state of Alabama, John Merrill, Secretary of State, about, they had tried to raise their taxes beyond the lid, and it ended up in a countywide vote, and there was some confusion about, it was labeled Amendment 1 here, and it was labeled Amendment 2 over here. Well, it didn't pass. And so Homewood was not allowed to tax itself beyond that, so now they have sued the Secretary of State. So the lid bill problem is a real living, breathing thing. We'll have to do another because it really helps when you understand that there was this, constitutional ban on, nope, you can't raise taxes past this. It's just like, even if you want to tax yourself, you can't. So how do you improve your schools if we're already relying on local property tax because the state, it's been shown, does not adequately provide state funding for schools. How else do you improve your schools? And of course, it's not always money, but money sure does help. Okay, so we're going to go to, I have a couple of questions that are kind of similar, and I'm going to kind of throw one on top. We have questions about segregation academies, which I've just recently done some research on too, and the effect of black flight on inner city school systems, right? And which takes me, that's kind of a different topic, right? But in a way it's not, because it's about resources going elsewhere, which desegregation was supposed to prevent. But I've always wondered, how did a system like Midfield gain unitary status at a time when all of the white people left? And is it one of those cases that's just, well, Midfield's actually still ongoing, isn't it? They have not, yes.
I think Midfield is, I can check my list, but I think they're
Where's my phone? I'll take a picture of it. What's your list say, Mr. Colvin? But so, it's like, how do you gain unitary status? Sumter County, I'll throw out Sumter County because I've done some research there recently, and they just have a case that's sitting on the shelf. All the students, all the white students left in the 70s and went to Sumter Academy, which was a segregation academy. Or they went to Marengo County schools or Demopolis City schools or somewhere else. White people were not going to go to school in Sumter County. And that case is actually still open. It's just not active. And it's interesting. I don't want to say anything, but a charter school has opened there, and it is integrated as opposed to just desegregated. But if there's a desegregation order, it's like, what could happen here? There's some, things that are up in the air with that. But talk about segregation academies. You probably are in the best position to speak about this. What did that do? When the federal courts came in and said, you will integrate, and white people said, but I'm not going to put my children in schools with black children, so we're going to go over here and start our own schools. And it had an impact.
It froze them in time, didn't it?
Yeah, absolutely. I mean, that's what it looks like all throughout the Black Belt. You have those counties are 99 or in some cases 100% black public school systems. Many of the segregation academies have quote unquote desegregated. They have taken on a small presence of African American students, sometimes through necessity, and that's really the shame of it all, because you look at some of those places, and not everywhere is like Lee County, where the segregation academy there, which is a fusion of two different ones, is doing okay. A lot of the segregation academies are in a shoddy state too. And so educational opportunities poor for everybody.
But AAA has supported some of those.
The Alabama Accountability Act.
Well, it's interesting. So the Alabama Accountability Act is a different thing, okay, out of the school desegregation, but it's basically sort of a use of money that would go into the Alabama taxpayer coffers to pay for children who are in low-income families to attend some other school than the public school that they're zoned to. And those schools, some of them are segregation academies, but many fewer than you think. Because I thought, oh, here we go. This is going to be a story in a couple of years. I'm going to look and see where all the money went to segregation academies. The money's going to religious schools. Yeah. The majority of it is going to Catholic schools and to other Christian schools. And some of those Christian schools were formed as segregation academies. They were just called Christian schools. And Nobody sort of wants to acknowledge how they were born, but any school that cropped up between about 1953 and about 1970, you kind of have to ask yourself, what was the impetus for it to form? And most of the time it was to avoid integration. So, but the Accountability Act itself has not fed as many segregation academies as I expected it to.
But it was pitched initially, right, as to help those who were in failing schools have a choice, right? Well, then they amended it, and now you don't have to be from a failing school anymore. And so, in my opinion, if you have studied this history, you know that there have been numerous attempts to establish a tuition grant program, which were shot down by the courts, rightly so, at least 3 times, maybe 4. Early on, yeah, and then it went dormant for a little while, and then this comes up, and if you study the history and you look at those tuition grant bills and you look at this one, there's a real similarity there.
There is a similarity, and that was why it raised I was just doing my own historical research, but there again, so I looked at the people who provide the scholarships, the majority of them, they're going to children of color. They're not going to white kids. They're going to Hispanic kids and to African American kids who are trying to find somewhere else to go to school other than where they're zoned to. So that was kind of a surprise. And there's a lot more research that needs to go into what effect is the Accountability Act really having. But I had those same concerns. Oh, this is just a tuition grant program in disguise.
Yeah.
Freedom of choice. Wait, school choice? Wait, who's pushing that again? And so it does it feels a little kind of eerie sometimes, like we're trying to repeat history and allowing choice. That means that white parents can choose here, but also black parents can choose here, right? So I don't know, that's like a whole nother topic. More questions?
To answer your question about how does a district get unit, it's just because the framework and the way that the courts look at a system. If you have a system like Midfield, that all of a sudden, if it's almost 100% African American, which it is, then and you start applying the analysis, then student assignment, there's nothing to look at. It is unitary. It's not desegregated, but it's unitary. It's one system because all the kids that live there go there.
And this is what I thought happened to most of the black belt cases that were splintered off of Levy-Macon. I didn't even realize Sumter was still open and not inactive.
Have a little help finding that out.
But the key is, and I think the sort of next logical question is, well then how did the segregationist academies, why didn't they get wrapped up into that? And it's just a question of jurisdiction, right? And whether the federal court at that time had jurisdiction over private schools or over individuals. Because remember, this is the whole problem with what happened originally is it's the government. And the government can't and it's all about constitutional rights, and the government can't violate those constitutional rights. Individuals, on the other hand, they can go to church where they want, they can go to school where they want, and so I think it would have taken a whole lot, and probably would have been reversed at that time as well, to actually reach into, based on the law, the legislation at the time, to reach into those private schools and try to pull kids back. Now, the Charter School Act itself has some language in it which makes it very clear, because the Charter School Act is legislation, right? And charter schools they're receiving state money and public money, and so it actually requires a desegregation type analysis in districts where they're still under desegregation orders.
And I can tell you, I won't name names, but I just recently discovered that one that was trying to open in a district with a charter school that was trying to open in a district with a desegregation order just couldn't figure out what to do next. And so even though they had been approved to open, they just sort of said, bye, this is too hard. So, depends on where you sit on that side of the fence, but like some people said, well, look what this charter school, it was a national they've done a really good job with kids of color and kids who were poor. And now those kids don't have that opportunity. So Whit's over there whispering. But, everybody's got their own opinion about charter schools. But I want to ask this one, because it's a question I get too. how is the government involved in the integration of other races, right? Is this just all about black and white? Can you speak to that, please? Because I really don't know. I didn't know, I didn't know if I'm a Hispanic student and I feel like, you know, and can I enter under can I get representation and say, you know, y'all are not providing me equal opportunity? Okay. You getting some?
Well, the reason I'm looking like this is because I don't know that the answer is yes, that there's a role. It's not just about Caucasian kids and African American kids, but the standards for that are fuzzy and courts handle it different ways. So yes, it matters. How does it matter, and is there a framework for it? I've asked that question too,
Okay.
and you get different answers from the other parties depending on. They say, well, sure, it matters, but they don't exactly say how you do it. Does that make sense?
Yes, I've been running into that a lot.
See, me too.
Yeah.
But it absolutely matters. And so what we do is we have to look at that data too, and you figure out what it does, and you want to know what it does. For the most part, you don't see it's not common to have when you look at the data to have data concerning those groups which have a great impact on really the fundamental data we're looking at, which is the relationship between African American children and Caucasian children in terms of assignment.
Because those are our two largest groups
They
in
are.
Alabama. In other states, obviously, they have other groups that are much larger, but those are our two.
But what you do get is you get this. It's like you get a number of you'll have people who just assume that, you know, you'll get a description of a school population, for example, faculty population, like, oh yeah, well, you know, we're 23 Caucasian and 5 minority. And it turns out that you've got an Asian American, you know, a Latino and 2 African American. And that sort of analysis, like for that purpose, what we look at is we look at the Caucasian and the African American. You don't get sort of credit for that when you're looking at the relationship between those two, because the cases were filed on behalf of African Americans.
Right, and that is where the biggest injustices were, right? And there's no arguing that, even to this day. Gosh, these are some of these are not quite related to this and would take us down a real rabbit hole, and we've got like 10, is anybody holding on to any question right now? Okay. So I'm going to go through these.
Save the rabbit hole ones for last.
Ooh, I know. Okay, so this question here is also one that I have gotten, which is it responsible to get out from under a desegregation order at this point where we are in time, right? Is it naive? Is it well-intentioned, but like you said, when people get out from under these orders, they often resegregate. There's no real big, hammer that you can say you need to do the right thing by kids.
I'll offer first, and then my colleagues can answer, because they're going to have a different answer than me. I think. I mean, my answer is that whatever the philosophy is, I mean, we're required to move in that direction. We have the court orders from 70 years ago that said you need to do this with all deliberate speed, right? Do it. It's your obligation to become unitary. And so we have an obligation to do it, whether it's useful in another context or not. But then I'll leave my colleagues to fill in the blanks on that.
I mean, maybe it seems silly to say now because it's been half a century, but our system of federalism would tend to not permit you to be under a federal court order in perpetuity. What I think we've got to do is learn from those cases where resegregation has occurred, learn from what happened in Tuscaloosa with Central, learn from other examples, and put the safeguards in place before you get that unitary status to make sure that those kinds of things don't happen again.
And that's up to us, y'all. These three will move on, and they don't really have, communities are the ones who have the power to say, this is unacceptable to us. We don't want this to happen in our communities.
And that's one of the huge factors why when you're obtaining unitary status, you be very mindful of what you're putting together, because you want to put something that is there, not just for number sakes, but you want something with longevity. You want something that's going to be there, that's going to continue to allow it to kind of do it on its natural own course, where you don't have to continue to step in and have those repercussions like you do in other districts. So that's one of the things that we really are trying to be very, very mindful for, doing it for longevity. That's very important, because at some point in time, it won't be a WIT or a letter or Dr. Pouncey or something, and you want something where someone else can come in and it still does the job.
Well, then hopefully, if what we all can agree hope happens, that these kids, not just us, but these kids can learn about each other and from each other, then the leaders of the school systems and the state governments a generation from now will be more responsible, right? And that you'll have a better chance that down the road, we're not going to be sitting there asking ourselves these questions.
I like that response. That's the most hopeful thing I've heard in a really long time.
Well, after so many people finished my book and said, well, I'm really depressed now.
It's pretty worrisome.
That's the sequel.
Right.
Well, and I don't want to forget to say this, because I'm not being asked to say this, but I asked Dr. Bagley to bring copies of his book in case anybody
Well,
wants.
I think I only mentioned it about 15 times.
No. My father would have loved this book. My father was an avid historian, and he would have just gobbled it up. And so I know that, this is a really age-wise, this is a really diverse group that we have here. So he does have a few copies, not a whole lot, but it is available on Amazon, but you won't get it signed on Amazon. This is why I had this panel tonight, so Dr. Bagley would have to come and sign my book. So I appreciate that. Y'all all participated, and I appreciate that. One last thing, we've got a few more minutes, because this is really relevant right now, and it's very relevant to Jefferson County, and I see a couple of references to it in a different way. Jefferson County has 12 school systems, right? It's one county and 11 city school systems. And I think it's fair to say that the majority of those, the majority of them factually did break off after Brown v. Board. The majority of
Can I interrupt you just quickly and say, that just makes their job so much harder.
Right.
Everything about that makes the mountain of work that they have to do all the more.
Absolutely, because Jefferson County is really unusual in that it has so many school systems. You look at Florida, they have 67 counties, I think, and they have 67 county school systems. Because they got a whole lot of school choice down there. They've got charter schools and vouchers and all sorts of things. But every time a city system breaks off, and there's disagreement, really a philosophical disagreement about this, that should city systems be allowed to grab their toys and move out here and say, y'all don't get our tax money anymore. Sorry kids in the county, but we want better for our kids. And that's the visual that I have in my head, by the way, except it needs to be a block of toys. Taking my toys and I'm going over here and you can't have any anymore. And there is a group that says...
Except that you're sweeping them all up.
Yes.
What happens is you take that toy, and
You're
that
right.
toy, and
I
that
want
toy.
these two
I want
toys.
those
Right.
toys. I
You're
don't
exactly
want
right.
those toys.
But not that one, because
not
that
that
one's not good anymore. I don't like it, or it wasn't as expensive.
That was the attorney's.
I've just been through this.
Right, okay. But it's true. So, and we've just seen Gulf Shores broke off from Baldwin County, and they're in a big kerfuffle. Baldwin County has now sued the state superintendent, basically saying that he's power hungry. I don't know how else to say it, and I know this is Facebook Live, but that's what they've said on, that's what Baldwin County has said, is he's using, he's like enjoying his authority too much here. Other school, Atmore, down in South Alabama, is considering breaking off and forming their own school system. Are you from Atmore? Oh my gosh, okay. So, I know all about it. And then, I need to talk with you. I'm taking this water. But also, Gardendale tried. Clay has talked about it, not recently. I don't want to start any rumors, but a lot of people, a lot of cities, when resources are scarce, as they have been, and there is no real end in sight, like you don't think the state is going to change the way it funds to provide more equitable funding for kids who are poor or kids who have special needs, communities start to think, well, how can we improve offerings for our children? And the only way we can do that is if we stop dividing our pie through so many kids. And that happens. And there's a group in Alabama, leaders, that think that's exactly what should happen. And in fact, that's kind of how the law is written. It kind of says, you know, you can be a part of a county school system, but if you become a city, once you become an established city, and you've got enough resources, you should go like a son leaving home and, you know, finding and establishing its own family or something. And so cities have done that. And that is, I think it's fair to say, a real challenge when it comes to desegregation and making sure that kids have equitable access. Is that fair? Well,
It just depends on which perspective you're looking at.
right.
And
And
which
there are
kids,
two perspectives.
and which kids you're looking at, and
Right.
there are two perspectives to that. There's been after the Gardendale case really put the spotlight on a national spotlight on Jefferson County and this very issue, and there are some wonderful articles written about it. There's some nice graphics, which you love, I'm sure, than ProPublica and some other. We had the Washington Post and the New York Times, and the New York Times long form magazine did an article on that. And I think there's some professors who are doing some great work really to looking at data related to school separations and how it affects resources. And I mean, we have we have a balkanized county here. And I mean, it's people from other places come here and they're shocked that we have as many municipal school systems as we do. I mean,
Yep.
but that said, y'all, I mean, other cities too. I mean, you go to other cities, you go to Atlanta, you go to Mobile, you go to New Orleans. They're doing the same thing. It's just done with parochial schools or private schools. Montgomery, I mean, you only have really two. You have two public school systems, but you've got this private school system that a number of them, and they function a lot like our public schools do here. I don't know. There's a lot more. There's
a lot of work.
There's a lot of work to be done there, and a lot of data to analyze. And
Okay, wait. It's 8:27.
One of the things the league does is we try to start on time, we try to end on time.
Okay.
And we always like to leave a discussion with a lot of provocative, thoughtful things for you to go out and to work on yourself, to talk with your local and state policymakers about, and to find out for yourself how you think you should act and vote and interact with the policymakers who got us where we are today. And there's elections all the time, and you have an obligation to be informed and to make your voice known. And I will say that the League has been in the forefront of integration for schools and quality education for decades. And we were a friend of the courts to the Supreme Court in some of those cases in the 1970s. So it's good that we are back here again having this discussion. Thank Trish for a stellar panel. If we have a rabbit hole question, we will try to get that answered and put it on our website. We thank you all for being here with us tonight.
thanks for having us.
This is for